Hello everyone, my name is Tui. Sorry for the wait. We were having some technical issue. My name is Tui, pronounced she, her, and I will pass it to Troy.
Hello, everybody. I'm Troy Pickard. I am an attorney here in Portland with the firm Portland Defender, and my firm has enjoyed a wonderful collaboration with the Community Alliance of Tenants for many years now, and just brings a smile to my face thinking of the folks at CAT and all the people we've been able to help. I'm happy to be here today.
Thank you. I would just like to go into a section of our meeting, which is land acknowledgement. And we say that this land acknowledgement is recognition of truth. We say this land acknowledgement shows respect. Today, there are 9 federal recognized tribes in the state of Oregon, but before settlers came to take the land here in Oregon, there were more than 60 tribes in this area. And we acknowledge that we are on occupied homeland of indigenous communities in Oregon. Now, who is Oregon? Who is CAT? CAT was formed in 1996. It stands for Community Alliance of Tenants. It is a Oregon oldest grassroots tenant-led tenant rights organization. And our mission is to educate and empower tenants to demand safe, stable, and affordable rental homes. Tenant power equals education plus organizing plus advocacy. So I would like to talk a little bit about the Tenant Protection Team, which is the TPT team. We partner up with SCI, Apano, and ARCO. The TPT programs work directly with tenants to provide information and suggestions. We help renters advocate for themselves. We provide letter writing assistance if you need it. If you are having trouble voicing yourself to your landlord, we will help with that. Also, renters qualify for free legal assistance with Troy Pickard, who you just met at the Tenant Defender. So you can reach me at joy@oregoncat.org, and you can reach twee@oregoncat.org. And our numbers are here on our PowerPoint. I'm going to dive in a little bit about terminations and eviction process. There are 3 ways that a landlord can serve you in an eviction. One is he can personally deliver the notice to you. He can first, he can mail it to you as well, but he has to add 3 extra days. So if the 3 extra days is not added, that is an invalid notice. He also can post it on your door only if that is in the rental agreement. So those are the 3 ways that a landlord can serve you a notice. Only a judge can give you an eviction, but if you get an eviction notice saying you have to be out in a certain amount of days, those are the 3 ways that he can deliver it to you. So termination versus eviction. Terminations must be written properly and delivered. Notifications that the landlord is ending the lease, but may also identify why tenant is in violation. So it has to let you know why you are in violation of the lease and a deadline to resolve the issue. It doesn't show up on a tenant's eviction, which is good, eviction record, which is good. So a landlord can still decide to give a bad reference. Doesn't always lead to an eviction, if that makes sense. And here are some samples of of notices that are lease agreements that you might see and that might be given to you. So termination versus eviction. Evictions are filed by landlord against a tenant, also known as forcible entry and detainer, FED. And it can only be filed in court after the landlord has properly delivered a termination notice to the tenant and the tenant has not complied with the deadline noted in the termination. So it requires the landlord and the tenant to appear in court, must appear in court and show up on your rental. It will show up on your rental history eviction record, even if it was dismissed. It will show up. And I think I'll hand it to Twee because I have some background noise.
Thank you, Troy. And we can invite you to share a little bit about how the tenant can clean their eviction record.
I just want to, are you asking me to do that?
Yes.
Yes.
Oh, I would love to tell you about how you can clean up your eviction record. Okay, so if you get an eviction case filed against you in Oregon, then that case is going to show up. If anybody does a search for your name, they will find that case. And the Oregon's court records are publicly accessible, so anybody could do a search. And there are some rules, and the rules that exist are, for example, a landlord is not allowed to use an eviction case against you if you're applying for a new home. They're not allowed to use an eviction case against you if you won the eviction case, right? Why should anybody be allowed to use that against you? So, for example, we have a law and it says a landlord who's considering renting to you as a tenant cannot use against you the fact that your landlord previously filed an eviction case against you, but somehow you won the eviction case. And I thought, look, this is crazy, because asking someone not to think about something is really hard. Like if I tell you, don't think about a rainbow colored panda bear. Well, as soon as I say rainbow colored panda bear, you're thinking about a rainbow colored panda bear. So it's really hard to tell people that. And I thought to myself, if landlords shouldn't be able to use that information against a tenant, then landlords really shouldn't be able to see that information at all. And so we got a law passed just right before the pandemic, and it allows tenants to expunge from the public record certain eviction cases. And one type of eviction case that you can definitely expunge is a case where you, the tenant, won the case. I think now there is an automatic expungement process that takes place for certain people, but it only happens once a year, and you might not want to wait around. So if you wind up having an eviction case filed against you and then it gets resolved, or let's say you have an old eviction case that you're worried might be on your record, if you can confirm that it is showing up in court records, then there's actually a motion you can file. A motion is a request for the court to do something. And it's a motion to expunge the eviction case from the court record. And I think that the law in question is, for anybody who wants to be a nerd and actually look the law up, nerds, is not the one that I just typed in. So let's see if I can get it right the second time. I did. 105.163. That's ORS, Oregon Revised Statutes, 105.163. And there you can see the specifics for yourself. The people who are eligible to do this are folks where the eviction case was something that the tenant won, where the eviction case was resolved by an agreement and the tenant did everything they were supposed to do under the agreement, or even an eviction case that the tenant lost. If it's more than 5 years old and the tenant has satisfied any money award that was included in a judgment that might have been entered against them in the eviction case. And there's also one that's becoming less and less relevant, but it's you can always expunge an eviction case if it was an eviction case based on something that came up during the pandemic between April 2020 and the end of March of 20 or the end of February of 2022. So remember we had a pandemic a couple of years ago. Yeah. Anyway, it's something that you can do on your own if you want to try to do it on your own. Might be easier to do it with a lawyer's help, but you can certainly try to do it on your own. A lot of county courts have forms for this exact thing available on their websites. And it certainly is something that my firm and probably other lawyers out there help people with as well. I know that there is a clinic through Portland Community College called the Clear Clinic. And I believe that one of the things that they can help people with is this process of expunging those eviction cases. So I'm delighted that Oregon has come out of the Stone Age and really in some ways is actually a leader in this, because when we got this law passed, there weren't very many states that had something like this. And I'd like to think that Oregon is now a model for some other states who might decide, hey, we need to do something like this in our state.
Great. Thanks, Troy. And before we continue, can I ask you to share a success story that about a TPT refer that to get maybe to share out there that the work that you've
The
done?
only thing hard for me about that would be to only share one success story, because there's been so many fun success stories with the TPT program. But you know, when people are referred to my firm through the Community Alliance of Tenants TPT program, I never know what I'm going to get. I could get somebody who's trying to keep their housing and the landlord's trying to kick them out. It could be a situation where a landlord is trying to force them to pay money that they shouldn't maybe have to pay. It could be something where we need to get the landlord to change something, like they need to fix things. But thinking about a few recent success stories, you know, there was one where a tenant lived on an upper story of a home, and there was no elevator, and there wasn't really a good way of, like, you know, installing a ramp. And this disabling condition really made it difficult for this tenant to live in the home. But the problem was that the tenant had a fixed term agreement. And so if the tenant normally was going to abandon their home in the middle of the fixed term agreement, the landlord had set up the contract so that they could take advantage of an Oregon law that allows them to hit the tenant with a 1.5 month rent penalty. So in other words, if he were to move out at the end of September, even though he was gone, the landlord would still be able to charge him for essentially all of October and half of November, even if the landlord gets another tenant in there right away. But through the TPT program, we were able to get the landlord to waive that early termination fee so that this tenant who suffered this disability was able to move to a more appropriate home. And of course, you know, it was already going to be expensive to move, but they didn't also get saddled with an additional, you know, 6 weeks of rent. So that was a big deal to that tenant. Another one was, gosh, let's see, we recently had a tenant who came to us and they had a bunch of repair problems at the home. And the landlord had been ignoring them, and we were able to get the landlord to fix all of the problems and pay the tenant thousands of dollars for the time that they had been stuck there having to live with those repair problems like that. I want to say there are also a lot of other TPT situations out there where there maybe isn't necessarily some fabulous outcome that we get, like, oh, we forced the landlord to pay thousands of dollars, or we got the tenant out of this big debt. But there are a lot of people that come to us through the TPT program that just need some solid advice about their situation so they can make a good decision about what to do next. And so with those folks, it's not necessarily about forcing the landlord to do something that they otherwise might not do. It's more just about kind of being a jungle guide and helping these folks, you know, not get eaten by a tiger or not get, not drown in a river full of piranhas. And so they don't always find, there's not always treasure to find. Sometimes it's just about escaping the jungle with our lives. And that's something that we often are able to help tenants do in the TPT program. Twee, back to you.
Thank you. And I see that you put in the chat with some information that you can contact TPT staff and our hotline to get help if you need to talk to us, and maybe to get a refer to our partner at the Portland Defender. Troy is here to help. And let me continue sharing my screen for the presentation. If you have any questions, please put in the chat, or you can wait until the end so we can take your questions. Thanks for your patience. So the next thing that we wanna give you some tips on if you have a court day, that you may wanna arrive early for parking and security check, because it takes a while to find parking downtown Portland. And from this part, we're gonna talk just about Multnomah County Courthouse. And so the downtown Portland is hard to find parking, and if you drive, and security it may take a while to get through, so you may want to be there early, because your court time may be around like 9 a.m. in the morning, right? You may want to bring an advocate, a friend, or family member there to support you. And of course, we always encourage tenants to seek for legal advice and learn about the court process ahead of time, because it can be stressful for a tenant to get a court day about eviction. And carefully review any documentation before signing. We know that many cases, landlords go to court with an attorney, or maybe just an attorney is there to represent the landlord, and they're gonna push you to sign some kind of agreement. So be careful. When you sign anything, review them, make sure you understand them and you can follow them before you sign. And the court process may take a few hours. I see that the hearings, they send everyone in the Multnomah County Courthouse, they send everyone the summons for like 9 a.m. or 8:45 a.m., but they call people by name in orders, and it may take a few hours to get called and get things sorted out. So you may want to plan things accordingly. And if you can observe a court process ahead of time. If possible, you can do it online or you can do it in person, and we're gonna go into detail about how to do it online later. And this is one sample of an eviction summons for first hearing. I dashed the information of the tenants, but there is plaintiff information and defendant put tenants information and their address and what is the day and the time that they can come, and the information down there with the eviction defense program, who they can call to seek for legal advice. And we found some pictures online to show you how the Multnomah County Courthouse look like outside and inside when you get in. And when you go through the security check, you can go upstairs for the crane room. That is the courtroom for landlord-tenant cases. And this is a picture of how the courtroom gonna look like. It's not exactly the same, the courtroom of the crane room, because we cannot take picture in there because it's their room, but we found the picture online for inside of the courtroom that you can look. It's gonna be much like this. And how about if the tenant cannot make it in person for some reason, you cannot be in the courthouse for your hearing, so you can call the WebEx that they have. This is the link that you can call. You can log in. You can call by phone if in the summon paper. Just have the phone number to call and the code. But you can also call through WebEx. You call this website and it's gonna be look like this. You can go to the left corner to choose court calendars and live stream proceeding. And you can choose to see today hearing and live stream or the future hearing live stream. And then it's gonna show you this page, which it have the link to landlord tenant cases. You wanna go to the landlord tenant cases and then click on that. And this is the phone number on the right side, phone number 503-388-9555 with the access code that you can access 249-0836-2270. I don't know if the code changed by time, but when you log into this page, when you go to this page, it's going to show you the phone number and the code that you can call if you cannot go to the website. And we want to mention the Legal Resources Center. It's going to be really helpful if you can go to the Legal Resources Center ahead of time to be prepared or early of the day. And they are on the second floor of the Monroe County Courthouse. They provide legal resources, but they don't provide legal advice. Their hours would be Monday, Tuesday, Thursday, and Friday from 8:30 to noon, and then they have 1 hour break time. Then they started at 1 to 4 p.m. And this is the phone number and the email that you can email them or call them if you need their or schedule something ahead of time. And they do serve people on the first come first serve basis. And when you have forms that you need to fill it out, you can fill it out and ask them to review the completed forms. Sometimes tenants don't know how to fill the forms, but maybe you can start with name, address, and things like that, so and they can have it correct. They have staff who speak English and Spanish, and they do also have interpretation service available through the phone for other languages. If you ask, they can call a person on the phone to help them with language assistance. And this is their flyer. And we want to show you a sample of the form if the tenant and landlord go to the first hearing and the judge not gonna rule on the first day. So they're gonna explain the process and ask the landlord and the tenant to walk out of the room to make an agreement. So this is the form of the agreements. It's called stipulate agreement. If the tenants and landlord agree to sign on this, it can be a payment plans or for future rents or any terms that they wanna fill it out. And please remember when you sign this, you have to follow this because it got filed with the court, and if you violated this agreement, the landlord can come back to court and file for non-compliance. And what if the tenant at the hearing, they cannot come up with an agreement with the landlord? So at that time, they're gonna ask for a trial. So when the tenant asks for a trial, they have to fill out this form called the answer. And they have to turn it in by the end of the day, same day. And that you can see that the landlord's name, the tenant's name, the case number, and if they need interpreter like Spanish, ASL, or any other services, any other languages, sorry. And why they deny the landlord eviction. And they can check the box and they can add any details on other pages if they need, and they all gonna sign in here. And if tenant qualify, they can fill out the fee waiver form if they're eligible. And there is an information section that the tenant can fill that out and turn it in the same day. Or they can do it like before, I believe it's 2 days before the trial day. At least 2 days before the trial day. But I see many tenants do that the same day, same time with the answer. How about the tenant need interpreter? So interpreter services is available through the website or the phone number. They can fill out the form online and the phone number that they can call and request, or they can email the courthouse to request interpreters. And there are different languages that are available. And recently, when I go to the courthouse, I see that most interpreter service that available through the WebEx. So the interpreter gonna be online helping tenants, but mostly I don't see them available in person. So they're gonna be on the screen helping people when they need another language, and they're gonna translate everything in the courthouse. But I don't see them available outside the courthouse, which can be challenging for tenant because if they speak another language and they want to talk to the landlord outside of the courthouse about agreement and making agreement, I don't see that available, unfortunately. And how about childcare? What about people with kids and they have to attend court? So there is a free drop-in childcare program in the Monona County Courthouse, and if you're in different region, you may want to look it up or call the courthouse in your area to see if they're available. But at the Monona County Courthouse, they do have a free program for first come, first serve basic for the kids aged 6 weeks to 10 weeks. And the parents must be conducting business in the courthouse and remain on site. And this is their flyer and this information that I found online to the website. And we want to talk about two different resources that may be helpful for tenants. First would be eviction defense program that they serve people with a termination notice, and if they are losing their housing subsidy or they have a pending eviction case with the court case number, right? And they can call the 888-585-9638, or you can look it up online and they have the form that you can fill out online to get their help. And there is a mediation program for landlord-tenant cases from Resolution Northwest that you can call. That's 503-595-4830. So they are not lawyers, but they are professional mediators that they can help with disputes, housing disputes between tenants and landlord. And both parties have to be agreed to talk to them. They cannot force the landlord or the management to sit down and talk or be on the phone and talk to the tenants about a housing dispute. And one decided member meeting that we wanted to invite you to, it's gonna be on the Saturday, October 26th from 10 a.m. to 2 p.m. It's gonna be happening at Urkel Immigrant Refugee Community Organization. Thanks for their generous to let us use their community space. It's gonna be about renters' rights training, cat war election, and both for statewide tenants policy and priorities, and more. You can go to our website to sign up and join our member meeting. We are excited to see you there. And thank you for joining us today. This is our hotline information at 503-288-0130 on Monday, Wednesday, Fridays, and Saturdays from 1 to 5 p.m. and Tuesday from 5 to 8 p.m. Or if you have a question for Joy and me, you are in Portland, please call Joy and tweet at this number, email, and we will get back to you. All right, I will stop sharing and leave the space for questions. Anyone have question at the moment? I see a moment of silence So when we wait for people to chime in with their question, Troy, can I ask you to share maybe in your experience or your advice about what if people represent themselves? Oh, I see a question here. Is it illegal for a landlord to refuse contact about landlord-tenant matters?
Would you like me to speak to that question, Twee?
Yes, please.
Um, I think that no, it's not, as a matter of course, illegal for a landlord to ignore a tenant. But a landlord might do so at its own peril. So, for example, if a tenant says, "Hey, landlord, there's a tree in the backyard that looks like it's about to fall," right? And I think you might want to address it. I guess the landlord can ignore it, and if it's not a problem, then it's not a problem. But of course, if it then becomes a problem, now the landlord's got a pickle on its hands that it's going to wish it didn't ignore that issue. Similar, in a similar vein, you know, tenant, there's any number of things a tenant might complain about, and a landlord might be very foolish to ignore those complaints, because if it's something that's the landlord's obligation to take care of, and the landlord doesn't take care of those things, then they're likely going to have giving their tenant a claim to sue them. And so it might be a very bad choice for a landlord to just ignore that tenant. On the other hand, there are plenty of things that a landlord can probably ignore with impunity. So for example, a tenant says, "Hey, I'm interested in, breaking my lease early. Can you tell me what that would look like?" Well, the landlord has no legal obligation to respond to that. And so as a customer service issue, they probably should, but there's nothing illegal about the landlord just ignoring that. And the questioner says, if a landlord posts a notice for the tenant to meet them and then refuses to admit the tenant, is it any different? I'm having a hard time understanding that, but I think what might be happening is landlord says, "Hey, I'm giving you a notice. I'd like to meet with you to discuss. Why don't you come down to the manager's office on Friday at noon?" Okay. I've never seen something like that, but I can imagine it. And then the tenant shows up on Friday at noon and the landlord says, "Never mind, we don't want this meeting. We're not going to let you into the office." Okay. I don't think they have a legal obligation to let you into the office or meet with you. If you write to your landlord and say, "Hey, I really want to have a meeting or a phone call to discuss something going on with my tenancy," then certainly from a customer service perspective, a landlord should say, "Hey, yeah, what's on your mind? Let's find a time to talk." But legally speaking, the landlord wouldn't be doing anything illegal by just ignoring that tenant and not responding at all. So Tweed, you wanted me to talk about the the dangers of representing yourself in eviction court?
Yes, and like any advice for the tenants who cannot have legal representation for their eviction day?
Well, most landlords who are in there have legal representation. And even if they don't, most landlords who are in there without legal representation have probably been through this process before. And they might well know more than you, the tenant, does about many different aspects of this process. So, be wary, because if you go to court and you don't have a lawyer working for you, then you're swimming with the sharks, right? There are going to be, there's a good chance that the people that are your opponents in this case um, know more about the law that is relevant to the case. They know more about the court procedures and court rules that are going to be relevant to the case. And so if you go in with no lawyer, obviously you are going in operating at a huge disadvantage. That having been said, there are, of course, times, occasionally, where a tenant with no lawyer will actually win against a landlord with a lawyer. in court. But those cases are few and far between. I would say there are many, 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 many more examples of cases where a tenant goes into court without a lawyer and gets a terrible result, and they could have gotten a much better result, or maybe even completely won their case if they had had good legal advice going in. So if you find yourself summoned to eviction court, the first thing you should do is you should reach out to lawyers that represent tenants in eviction cases. Most lawyers would be able to look over the court paperwork that the landlord has filed, and if they can see a problem with the paperwork, then there are many lawyers out there, myself included, who may well be able to represent that tenant for free without charging that tenant a dime. Because what many people don't know is in these eviction cases, the rule is that the court can make the loser pay for the winner's legal bills. So my firm represents tenants all the time that could never afford to pay us out of pocket for our services. But we know that even though they're poor, that doesn't matter. They still have a case that we could win for them. And it's one that we think that we can ultimately get the court to require the tenant or the landlord to pay for the legal bills. And so we take cases like that all the time, and our clients pay us nothing. And like I was saying, you should be able to get a lawyer to look over the paperwork and at least be able to tell you whether there's some glaring problem that they see. And probably you'd be able to get that without it costing you a dime. Now, there will be cases out there where everything looks fine with the landlord's paperwork, but there's some kind of a defense that's not apparent from the paperwork. And a classic example would be a landlord tries to kick a tenant out because they say, well, you punched your neighbor in the parking lot. And the tenant says, well, actually, it was self-defense. My neighbor and his dog were attacking me in the parking lot. And yes, I had to punch him in self-defense, to stop myself from getting mauled by his dog. I had to escape. But of course, that's not going to be something that's apparent from just looking at the paperwork. However, what I can tell you about those kinds of cases, if they just boil down to he said, she said cases, is that it can be difficult to find an attorney for those cases, especially if you can't afford to pay your attorney out of pocket. Because if it's just he said, she said, and all that has to happen is the jury or judge just believes the other side and they don't believe you, that's a really difficult case for a lawyer to win. And if you're not able to pay your lawyer out of your own pocket, then your lawyer is going to say, well, the only way I'm going to get paid for doing this work is if I win the case, and I can't control who the jury believes here. So if the jury winds up believing your weirdo neighbor, then you're going to lose this case, and I'm going to do a bunch of work, and it's going to be work I've done for free. And like most people, I suspect, most lawyers don't like working for free. They don't mind working for free up front, and then when they win, they force the landlord to pay. That's great. That's the best possible scenario. But if you have a case that's truly going to hinge on just who the judge believes, whose testimony is believed, that's probably one of the most likely scenarios where you would need to pay a lawyer out of your own pocket. But there might be plenty of scenarios where a lawyer would be happy to work for you without you paying them anything. And again, those are cases where there's some reason why the lawyers should believe they can win the case for you and that the court will require the landlord to pay.
Thanks a lot, Troy, for the insight and advice on those cases. Any other question in the audience here? You can unmute yourself to talk, or you can put in the chat, whatever works for you. I see a question in the chat. Can a landlord just wait out the clock for paperwork they refuse to accept to force an eviction case?
I think I would need to understand better what is being asked there.
Can you explain more about the situation? You unmute yourself. Okay, they said that in this case they want a LIHTC recertification, but all attempts to provide it to them has been met with hostility.
Well, situations like that make me think that the tenant needs to figure out a way of communicating with the landlord that is not in person, because number one, that will serve as a buffer to the hostility. And number two, that is in writing, because that will create a clear record of what has happened. And so I can imagine a landlord saying, hey, I'm going to kick you out because you're not filling out your low-income housing tax credit recertification paperwork. And then the tenant, maybe for example, tries to go into the office to fill the paperwork out, and the landlord says, I'm not going to let you in here, making it impossible for the tenant, or potentially impossible for the tenant to fill the paperwork out, and leading them towards failing to resolve this thing they're being terminated for. So in a situation like that, I would say, you'd want to respond via email, and you'd want to say, hey, let me tell you what happened today. You wanted me to come in and fill this paperwork out, but when I tried, you wouldn't let me in the office. So feel free to email it to me, and I'll fill it out and I'll email it back to you. And I think that if a landlord refused to provide you with the paperwork that they wanted you to fill out, and then tried to kick you out for not filling it out, even though you'd been asking them to give you the paperwork so you could do it, I would be very concerned if I was that landlord about being able to win in court, because I don't think any judge in Oregon is going to be very impressed with the landlord who says, yes, judge, I'm trying to kick my tenant out for not filling this paperwork out, and I wouldn't give them the paperwork, so I made it impossible for them to fill it out. I think that the landlord that comes to court and that's the story is going to have a difficult day in court.
I see in the chat they said, thank you very much for your input. And I see a note from here from our teammate, our hotline team, saying that our hotline, we doesn't have a capacity to respond to emails. So if you have a question, please call our hotline during hotline hours and leave a voicemail. Thank you. Thank you for the question, and thanks Troy for the input. Any other question out there? We have about 12 minutes. I just want to add to what Troy shared about the communication with the landlord. We always take communication, documentation. Do it in writing so you have good paper trail. Because I see cases in court that tenants have good paper trail and they can win even without a lawyer, but they have really good paper trail and they organize their paper really good. And that, I think last week or 2 weeks ago, I was in court with a tenant that she didn't have lawyer. The landlord had lawyer, but she won because she had really good cases. She had witnesses, and it's what the landlord said, kind of hearsay. So documentation is a key. Any other question? Feel free to put in the chat or unmute yourself. Another question here, is it illegal for a landlord to post a notice months late, like dated July posted in August is hard to prove from my side.
A landlord has to prove in court when it issued a notice. So, for example, let's say that a landlord files an eviction. Let's say a landlord gives a tenant a termination notice because they say, hey, I posted a notice on your door on Tuesday morning, and it said that I was coming over on Wednesday afternoon for an inspection, right? So I gave you sufficient notice. And the tenant says, no way, that's not what happened, because I came home from work on Tuesday night and there was no notice on my door, but I did find a notice on my door on Wednesday morning. And you wanted to come over Wednesday afternoon. So you must have put that notice. I mean, you wrote on the notice that you put it on the door on Tuesday morning, but you didn't. You actually put it on the door on Wednesday sometime after I went to work and then I came home. And so, yes, I refused your entry on Wednesday because you had not given me a 24-hour notice. Well, that's going to be a situation where it's just going to be the landlord's word versus the tenant's word, because presumably there's no other testimony, no other evidence. The landlord is going to say, I went over to the house on Tuesday morning. I taped, I knocked on the door. Nobody answered, so I taped it to the door. I never went over Tuesday night. I never went over Wednesday morning. I went over Wednesday afternoon for the inspection, and the tenant refused my entry. And the tenant is going to tell their story, right? They're going to say, no way, there was nothing on the door on Tuesday night. There was nothing on Wednesday morning. I know because I went out the front door. I went to my car. I forgot my coffee and I had to go back inside the house. So if there had been something taped to the door, I would have seen it when I went back inside. There was nothing there. Then I came home for lunch that day. And at noon on Wednesday, suddenly there was something taped to the door. So I can't say exactly when the landlord taped it there, but I know it was after 8 a.m. and before noon on Wednesday. And then the judge would just have to decide who they believe. But yes, it's often difficult, as we were talking about before, it's often difficult for to prove what happened when it's just your word versus someone else's. And it's true with so many things, right? It's true with unlawful entries. It's true with, whether there was damage to the carpet at the beginning of the tenancy. It's true with whether someone paid their rent on time or whether someone was making a noise disturbance. Frankly, there are a ton of opportunities out there for people to lie in court to gain an advantage, because we just don't have 24-hour video and audio evidence of everything that takes place. So yes, anytime you're dealing with an eviction case, you're going to want to think, even if what the landlord is saying, even if I know what they're saying is untrue, is it possible that the landlord can go to court and lie and get away with that lie? And the answer is yes. That's oftentimes something that's possible.
Thanks, Troy. I see in the chat here they respond. This very late notice actually gets on my case for not responding to them. So they'll evict me for not getting back to them in time. Sorry about this. And again, please call our hotline or call me or Joy directly so we can talk about it and maybe make a referral for you to Troy if you are qualified. Thank you. Any other question? I see a moment of silence here, so maybe we don't have any more questions. It's almost 1, so I guess we can adjourn early. Thank you, Troy, for being here. And thanks everyone for joining us. And I'll see you at the member meeting.
Thanks for having me.
Have a good day. Bye-bye.